approach, Your Honor?
Sure.
Thank you.
All rise for entering jury, please, jurors.
Okay, good morning, ladies and gentlemen. Does the state stipulate to the presence of the panel and the defense?
Yes, Your Honor.
Okay, at this time, ladies and gentlemen, I am going to instruct you on the law. Officer Hawks is handing out the jury instructions. Each of you will have a copy of the instructions. You'll be able to take them with you when you go back to deliberate upon your verdict. It is now my duty as judge to instruct you in the law that applies to this case. It is your duty as jurors to follow these instructions and to apply the rules of law to the facts as you find them from the evidence. You must not be concerned with the wisdom of any rule of law stated in these instructions. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. Instruction number 2, if in these instructions any rule, direction, idea is repeated or stated in different ways, no emphasis thereon is intended by me, and none may be inferred by you. For that reason, you are not to single out any certain sentence or any individual point or instruction and ignore the others, but you are to consider all the instructions as a whole and regard each in the light of all the others. The order in which the instructions are given has no significance as to their relative importance. Number 3, an indictment is but a formal method of accusing a person of a crime and is not of itself any evidence of his guilt. In this case, it is charged an indictment that on or about the 2nd day of September 2022 within the County of Clark, State of Nevada, contrary to the form, force, and effect of statutes in such cases made and provided, and against the peace and dignity of the State of Nevada, the defendant committed the crime of murder with use of a deadly weapon, victim 60 years of age or older, as follows. Did willfully, unlawfully, with malice aforethought, kill Jeffrey Gehrman, who was 60 years of age or older, with use of a deadly weapon, to wit, a knife, by stabbing the said Jeffrey Gehrman multiple times about the body, the said killing having been 1, willful, deliberate, and premeditated, and or 2, perpetrated by lying in wait for the said Jeffrey Gehrman, and or 3, perpetrated by abuse of an older person. It is the duty of the jury to apply the rules of law contained in these instructions to the facts of the case to determine whether or not the defendant is guilty of the offense charged. Number 4, murder is the unlawful killing of a human being with malice aforethought, either express or implied. The unlawful killing may be effected by any of the various means by which death may be occasioned. Number 5, malice aforethought means the intentional doing of a wrongful act without legal cause or excuse, or what the law considers adequate provocation. The condition of mind described as malice aforethought may arise from anger, hatred, revenge, or from particular ill will, spite, or grudge toward the person killed. It may also arise from an unjustifiable or unlawful motive or purpose to injure another, proceeding from a heart fatally bent on mischief, or with reckless disregard of consequences and social duty. Malice aforethought does not imply deliberation or the lapse of any considerable time between the malicious intention to injure another and the actual execution of the intent, but denotes an unlawful purpose and design as opposed to accident and mischance. Number 6, express malice is that deliberate intention unlawfully to take away the life of a human being which is manifested by external circumstances capable of proof. Malice may be implied when no considerable provocation appears, or when all of the circumstances of the killing show an abandoned and malignant heart. Number 7, the indictment alleges alternative theories of murder of the first degree, as allowed by law. In addition to willful, deliberate, Premeditated murder, the indictment alleges the defendant committed the murder by means of lying in wait and or by abuse of an older person. Number 8, one theory of murder of the first degree is murder which is perpetrated by means of any kind of willful, deliberate, and premeditated killing. All three elements, willfulness, deliberation, and premeditation, must be proven beyond a reasonable doubt before an accused can be convicted of first-degree murder under the theory of liability. Number 9, willfulness is the intention to kill. There need be no appreciable space of time between formation of the intent to kill and the act of killing. Number 10, deliberation is the process of determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action and considering the consequences of the actions. A deliberate determination may be arrived at in a short period of time, but in all cases, the determination must not be formed in passion, or if formed in passion, it must be carried out after there has been time for the passion to subside and deliberation to occur. A mere unconsidered and rash impulse is not deliberate, even though it includes the intent to kill. Number 11, premeditation is a design, a determination to kill distinctly formed in the mind by the time of the killing. Premeditation need not be for a day, an hour, or even a minute. It may be as instantaneous as successive thoughts of the mind. For if the jury believes from the evidence that the act constituting the killing has been preceded by and has been the result of premeditation, no matter how rapidly the act follows the premeditation, it is premeditated. Number 12, the law does not undertake to measure in units of time the length of the period during which the thought must be pondered before it can ripen into an intent to kill, which is truly deliberate and premeditated. The time will vary with different individuals and under varying circumstances. The true test is not the duration of time, but rather the extent of the reflection. A cold, calculated judgment and decision may be arrived at in a short period of time, but a mere unconsidered and rash impulse, even though it includes an intent to kill, is not deliberation and premeditation, as will fix an unlawful killing as murder of the first degree. Number 13, another theory of murder of the first degree is murder perpetrated by means of lying in wait. The elements necessary to constitute lying in wait are watching, waiting, and concealment from the person killed with the intention of inflicting serious bodily injury upon such person or of killing such person. Nothing requires that the lying in wait exist for or consume any particular period of time before the act which causes the death. It is only necessary that the act causing death be preceded by and the outgrowth of lying in wait. Where a killing is accomplished after lying in wait, the state is not required to prove premeditation or deliberation. The killing constitutes murder of the first degree so long as it was committed with malice, either express or implied. Number 14, another theory of murder of the first degree is a kind of murder which carries with it conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of abuse of an older person. Therefore, killing which is committed in the perpetration or attempted perpetration of abuse of an older person is deemed to be murder of the first degree, whether the killing was intentional or unintentional or accidental. This is called the felony murder rule. The intent to perpetrate or attempt to perpetrate abuse of an older person must be proven beyond a reasonable doubt. Number 15, any person who abuses an older person is guilty of abuse of an older person. Abuse means willfully causing unjustifiably pain or injury or mental suffering to an older person. An older person is defined in Nevada as 60 years of age or older. Number 16, although your verdict must be unanimous as to the charge, you do not have to agree on the theory of guilt or liability. Therefore, even if you cannot agree on whether the facts establish the defendant is guilty of willful, deliberate, and premeditated murder, murder by means of lying in wait, or felony murder by means of abuse of an older person, so long as all of you agree that the evidence establishes the defendant's guilt of murder in the first degree, your verdict shall be murder of the first degree. Number 17, all murder which is not murder of the first degree is murder of the second degree. Murder of the second degree is murder with malice aforethought, without the admixture of premeditation and deliberation, nor by means of lying in wait or by means of elder abuse. Number 18, you are instructed that if you find the state has established that the defendant has committed first degree murder, you shall select First-degree murder is your verdict. The crime of first-degree murder includes the crime of second-degree murder. You may find the defendant guilty of second-degree murder if, 1, you have not found beyond a reasonable doubt that the defendant is guilty of murder of the first degree, and 2, all 12 of you are convinced beyond a reasonable doubt the defendant is guilty of the crime of second-degree murder. If you are convinced beyond a reasonable doubt that the crime of murder has been committed by the defendant, but you have a reasonable doubt whether such murder was of the first or of the second degree, you must give the defendant the benefit of that doubt and return a verdict of murder of the second degree. Number 19, you are instructed that if you find the defendant guilty of first or second degree murder, you must also determine whether or not a deadly weapon was used in the commission of the crime. If you find beyond a reasonable doubt that a deadly weapon was used in the commission of such an offense, then you shall return the appropriate guilty verdict reflecting with use of a deadly weapon. If, however, you find that a deadly weapon was not used in the commission of such an offense, but you find that it was committed, then you shall return the appropriate guilty verdict reflecting that a deadly weapon was not used. Number 20, deadly weapon means any instrument which, if used in the ordinary manner contemplated by its design and construction, will or is likely to cause substantial bodily harm or death, or any weapon, device, instrument, material, or substance which, under the circumstances in which it is used, attempted to be used, or threatened to be used, is readily capable of causing substantial bodily harm or death. 21, the state is not required to have recovered the deadly weapon used in an alleged crime or to produce the deadly weapon in court at trial to establish that a deadly weapon was used in the commission of the crime. Number 22, in arriving at your verdict in this case as to whether the defendant is guilty or not guilty, the subject of penalty or punishment is not to be discussed or considered by you and should in no way influence your verdict. If your verdict is murder of the first degree, you will, at a later hearing, determine the issue of penalty or punishment. Number 23, to constitute the crime charged, it must exist a union or joint of an act forbidden by law and an intent to do the act. The intent with which an act is done is shown by the facts and circumstances surrounding the case. Do not confuse intent with motive. Motive, what prompts a person to act. Intent refers only to the state of mind with which the act is done. Motive is not an element of the crime charged, and the state is not required to prove a motive on the part of the defendant in order to convict. However, you may consider evidence of motive or lack of motive as a circumstance in the case. Number 24, the defendant is presumed innocent until the contrary is proved. This presumption places upon the state of Nevada the burden of proving beyond a reasonable doubt every element of the crime charged and that the defendant is a person who committed the offense. A reasonable doubt is one based on reason. It is not mere possible doubt, but is such a doubt as would govern or control a person in the more weighty affairs of life if the minds of the jurors, after the entire comparison and consideration of all the evidence, are in such a condition that they can say they feel an abiding conviction of the truth of the charge, there is not a reasonable doubt. Doubt to be reasonable must be actual, not mere possibility or speculation. If you have a reasonable doubt as to the guilt of the defendant, he is entitled to a verdict of not guilty. Number 25, the evidence which you are to consider in this case consists of the testimony of the witnesses, the exhibits, and any facts submitted or agreed to by counsel. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of the commission of the crime which has been charged, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances which tend to show whether the defendant is guilty or not guilty. The law makes no distinction between the way to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Statements, arguments, and opinions of counsel are not evidence in the case. However, if the attorney stipulate to the existence of a fact, you must accept the stipulation as evidence and regard that fact as proved. You must not speculate to be true any insinuations suggested by a question asked a witness. A question is not evidence and may be considered only as it supplies meaning to the answer. You must disregard any evidence to which an objection was sustained by the court and any evidence ordered stricken by the court. Anything you may have seen or heard outside the courtroom is not evidence and must also be disregarded. Number 26, in this trial, you heard evidence of other acts regarding the defendant, Mr. Tejas, in the articles written by Jeff Gehrman. You are not to conclude from this evidence the defendant is a person of bad character or is predisposed to commit crimes. Number 27, the credibility or believability of a witness should be determined by their manner upon the stand, their relationship to the parties, their fears, motives, interests, or feelings, their opportunity to have matter to which they testified, the reasonableness of their statements, and the strength or weakness of their recollections. If you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of their testimony which is not proved by other evidence. Number 28, witnesses who have special knowledge, skill, experience, training, or education in a particular subject have testified to certain opinions. This type of witness is referred to as an expert witness. In determining what weight to give an opinion expressed by an expert witness, you should consider the qualifications and believability of the witness, the facts or materials upon which the opinion is based, and the reasons for each opinion. Opinion is only as good as the facts and reasons on which it is based. If you find that any fact has not been proven or has been disproved, you may consider that in determining the value of the opinion. Likewise, you must consider the strength or weaknesses of the reasons on which it is based. You are not bound by any opinion. Give each opinion the weight you find it deserves. You may disregard any opinion if you find it to be unreasonable. Number 29, although you are to consider only the evidence in the case and reaching a verdict, you must bring to the consideration of the evidence your everyday common sense and judgment as reasonable men and women. Thus, you are not limited solely to what you see and hear as the witnesses testified. You may draw reasonable inferences from the evidence which you feel are justified in the light of common experience, keeping in mind such inferences should not be based on speculation or guess. A verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment and sound discretion in accordance with these rules of law. Number 30, during your deliberations, you're not to communicate with anyone in any manner regarding the facts and circumstances of this case or its merits, either by phone, email, text, messaging, internet, or other means. You are admonished not to read, watch, or listen to any news or media accounts or commentary about the case. You're not permitted to do any independent research, such as consulting dictionaries, using the internet, or any other reference materials. You are further admonished not to conduct any investigation, test a theory of the case, recreate any aspects of the case, or in any other manner investigate or learn about the case on your own. Number 31, when you retire to consider your verdict, you must first select one of your members to act as foreperson who will preside over your deliberation, will be your spokesperson in court. During your deliberation, you will have all the exhibits admitted into evidence, these written instructions, and forms of verdict prepared for your convenience. Your verdict must be unanimous. As soon as you agree upon a verdict, the foreperson shall sign and date the verdict form and return with it to this room. Number 32, now you will listen to the arguments of counsel, who will endeavor to aid you to reach a proper verdict by refreshing in your minds the evidence and by showing the application thereof to the law. But whatever counsel may say, you will bear in mind it is your duty to be governed in your deliberation by the evidence as you understand it and remember it to be, and by the laws given to you in these instructions, with the sole fixed and steadfast purpose of doing equal and exact justice between the defendant and the state of Nevada. The state may open and close the arguments.
Thank you, Your Honor. Morning. By June of 2022, Jeff Garriman had caused a lot of problems for the public administrator, Robert Tellis. He had written articles accusing Mr. Tellis of an inappropriate relationship. He had written that he was bullying in the office and had created a hostile environment in the public administrator's office. He had written an article saying that the management of Mr. Tellis was so bad that the county had to bring in a private consultant in order to assist with the management of an 8-person office. After Mr. Garriman wrote those articles, Mr. Tellis lost his primary race and would not be the public administrator after that. And not just that he lost the race, he lost the race to a rival within the public administrator's office itself. And from the text messages of Mr. Tellis, we learned that this was deeply, deeply troubling for him. He wrote to Mr. Gehrman, I don't know what to say. I told you how much this all impacted me. You heard from employees who are being harassed by these people, provided you, I think this is a typo, proof that I was doing my best to actually smooth things over. I had to make hard decisions. Still, you wrote an article that makes it sound like I'm the guilty one. That wasn't fair or balanced. He told Mr. Gehrman, I'm distraught right now. Clearly, there are typos in my message. He told Mr. Gehrman that he was adding to the pressure of his life. I've done so much for that office. I've told you that I've been followed and that I caught Rita following me. You decided to take it on her word that she wasn't. However, clearly she was. It seems to me that you value sensationalism or the value of a potential takedown than actually telling the truth. Thank you for helping him drop more pressure on my life. Now, Mr. Gehrman's response was a response that you get probably from many reporters. He says, sorry you feel that way. My editors and I feel the story is fair and balanced. Mr. Tellis's response, I don't know that you could truly feel that. You have concrete proof I provided you of what is really going on. You acknowledge much of it. You mention none of it. If telling yourself that you were fair helps you sleep at night while you're trying to destroy good people, that's your prerogative. And Mr. Tellis does attempt to fight back from these articles on his campaign website. He posts this letter discrediting the paper and discrediting the allegations in those articles written by Mr. Gehrman. He goes on Twitter and he accuses Mr. Gehrman of being a bully. He says Mr. Gehrman had threatened him. He told other people on social media in this first screenshot that because of those articles, I had to increase my medication to cope with it all. He tells someone who reposted the article or sent it that he was deeply disappointed that they had done that. And he's generally following the fallout of those articles on social media. But the reality is he lost that primary election after those articles were written, and he attributed it to the articles written by Jeff Gehrman. He told his best employee, Nicole Lofton, unfortunately, too many people bought the lies. He told his best employee, Nicole Lofton, I'm so sorry. I'm devastated that everything we worked for is going to be done. I hate them and what they did. And after all that happened and losing the primary, his concern was that another article might be coming. He explains, I'm going to pull the trigger on the supervisory changes. I'm going to go with the original plan. I think if I do any more than that, they will say I'm interfering with operations. And then he added, she is probably trying to get fodder to pass to the reporter. And he sent another text after that there's more garbage being gathered for a news article. And Mr. Tellis testified to you that after the primary took place, he actually half drafted, he didn't file it, a lawsuit where he was going to sue his rival, Rita Reid, and he was going to insinuate in that lawsuit, coincidentally, that there was a conspiracy that caused his problems in the election. If you look at point 21, he wrote, upon information and belief, several employees conspired to make false allegations of mistreatment by Mr. Tellis. These employees contacted the Las Vegas Review-Journal to share false and defamatory statements in support of news articles against Mr. Tellis. So he was clearly incredibly upset that those articles were written and that it resulted in him losing that primary. In July, Jeff Gehrman, though, isn't done with his stories and his examination of what is going on with Mr. Tellis and the public administrator's office. In July, he sends that request for the public records of the county, where he's asking for communication between Mr. Tellis and Roberta, and then ultimately it expands to other individuals in the county. But he wants all team messages between Mr. Tellis and Roberta. He wants cell phone messages. He wants essentially all of their communications as of July. And that's after those 4 articles were written. Mr. Tellis, of course, is informed of this request by the county, and this occurs on August the 8th. And they explain, hey, look, this reporter's seeking all of this information. So the message underlying all of this is another article is forthcoming. Mr. Tellis messages back that he wants to review those communications prior to them being released to the reporter. But as of August 8th, he's on notice of another article coming. And if you look at this email, he responds about 20 minutes after that first email was sent to him. Now, looking at the August calendar, you can see that on August the 8th, that's when he receives the notification of the public records request. And by August the 12th, there are images from Google Maps of Jeff Garriman's neighborhood, Bronze Circle. We don't know the date they were created, but we know they were modified by August the 13th, meaning they had to be created sometime before that. Now, this doesn't mean that Mr. Tellis physically went to Bronze Circle on the days leading up to the modification date of the 13th. It simply means that he went and accessed Google Maps, and Bronze Circle is the area that was searched and accessed by his phone. And those images are, of course, where Jeff Garriman lives. Now, the next date to keep in mind in our series of events in August of 22 is August the 15th. In August the 15th, that is when there's images of all of those cars that are kind of driving along the access road to Jeff Garriman's neighborhood. Now, once again, we have a modification date. That doesn't mean that the images were all taken on the 15th, but they had to exist before the 15th to be modified on that date. And if you recall, Detective Gaddis figured out where this was, and it's right off of Mr. Garriman's neighborhood. His house is right here on Bronze Circle, and she figured out by looking at the photographs where it was located in Las Vegas. And she figured out it was located right at this Popeyes parking lot, and that slanted wall ends up being in almost all of the images. And there are a lot of them, of several cars driving by the access road to Mr. Garriman's house. So we have the notification on the 8th. We have accessing Google Maps on the 12th. We have those screenshots of all of those vehicles in conjunction with Mr. Garriman's neighborhood by the 15th. And then by the 23rd, there have been searches of Mr. Garriman's personal information on Mr. Tellis's computer. This is Mr. Tellis's work computer at his desk. If you look at the screen on the right, you can see like there's a bottle of hand sanitizer, there's an arrow pointing to it. Here's a closer view. And the screenshots from his phone, you can see that the same cap to that bottle is in the screenshot as well. So these were clearly taken on his work computer while he was at work. And you can see that he's looking up personal information of Mr. Garriman, the kind of car he drives. He ultimately is able to get the address of 7216 off his work computer. And once again, those photos were in existence by August the 23rd of 2022. So all of those events, the notification, the accessing of Bronze Circle on Google Maps, the screenshots of the car, and then using the work computer to access personal information of Jeff Garriman all occurs in August of 2022. Moving to September, that's when Mr. Tellis, on September the 1st, receives notification that the county is getting ready to release all of those documents that were subject to the public records request. He's notified, and Ms. Kennan is notified on September the 1st of 2022, and the murder's the very next day. It's about 15 hours later. Now, we know that on the morning of the 2nd, Mr. Tellis left his house and proceeded into the area of Mr. Garriman's neighborhood, and that he kind of meanders around there, but ultimately ends up on those cross streets and then proceeds on foot to Mr. Garriman's residence. Mr. Tellis's residence is at the top of the screen there on Spanish Steps. He goes down that Silk Tassel Road and then goes on Red Hills Road. And he leaves at 9:12 in the morning. Now, eventually, he's in the area of Rock Springs Drive, which is near Mr. Garriman's neighborhood. The time on that video is incorrect. It says 9:42 a.m. But you heard from Detective Mogg that the corrected time for that particular camera is 10:26. So he's in the area of Mr. Garriman's neighborhood at about 10:26 a.m. in the morning. What's the next thing that happens? Well, you know that this is Mrs. Tellis's Apple Watch, and she sends that message to Mr. Tellis at 10:35 a.m. You can kind of see it says Friday, 10:35 a.m. And the message is, where are you? Well, he's sitting in Mr. Garriman's neighborhood, so he's not answering this text message. That text message goes unanswered. Mr. Tellis at 10:40 a.m. is now on Wintergreen Drive, which is the cross street to Bronze Circle. He's on Wintergreen Drive at about 11 a.m. and the murder itself takes place at about 11:18 a.m. Then Mr. Tellis is back at his own neighborhood by 11:51 a.m. And this is video from that Piggott Elementary School, which Detective Mogg indicated that that timestamp is correct. And what does he do? He gets back at 11:51 a.m. and then he's able to get his BMW and proceed to Planet Fitness. So there's his BMW leaving. It's 12:03, and then you know from Detective Gaddis's testimony that it's about a 4 to 6 minute drive. He's able to be at Planet Fitness by 12:09. So by 9/3, which is now the day after the murder, it has been reported that Jeff Garriman has been murdered. And then Roberta, who's working, has heard about the murder and she's starting to get concerned. She tells Mr. Tellis, I'm working tomorrow now. I don't want to be in the office alone. I'd rather be with the crazy women than alone right now. She's concerned about Mr. Garriman getting murdered and she's scared about being in the office alone. By September 5th and 6th, the Las Vegas Metropolitan Police Department has released images of the assailant and also of the Yukon itself. And Roberta becomes even more concerned. She messages Mr. Tellis, Rob, WTF, please do not be driving your Yukon around for a while. This is on the, September the 6th. He answers, whoa, that's crazy. She says, please tell me your Yukon is not that color. He answers, it is similar, if not the same. She says, I'm freaking out, Rob. He answers, my car has all matching wheel patterns. I think they are saying that there's a difference between the front and the back of the assailant's vehicle. But Roberta looks at it and says, fuck, your car is identical. And it actually turns out that Roberta is the one that is correct. His car is identical. From that lighter spot on the passenger side, just below the windshield wiper, there's sort of like a lighter rectangular shaped portion of the car. You can see that in the video. From the differentiating tint between the front and the back of the vehicle, that part is identical. And from the wheels themselves, they weren't different. They were the same. The wheel rims on the front and the back are identical. It is his Yukon. He is the one who committed the murder. So let's talk about the charge of murder. Murder is the unlawful killing of a human being with malice aforethought, either expressed or implied. And all that means is an act of ill will. When you go back to deliberate, you'll be asked two overarching general questions about the crime. And those are, was a deadly weapon used in the commission of the crime? And was the victim of the crime 60 years of age or older? So as you heard from Judge Levitt, a deadly weapon is simply an object capable of causing substantial bodily harm or death. We obviously have that in this case. The knife wounds inflicted on Mr. Gehrman were definitely not caused by human hands, and they were capable of causing substantial bodily harm or death, because that's ultimately what happened. You may be asking, well, where is it? Like that knife didn't come to court. But the instructions tell you that the state is not required to have recovered a deadly weapon used in an alleged crime or to produce it at trial. You just have to be able to gather from the evidence that a deadly weapon was used. Obviously, the injuries of Mr. Gehrman indicate that this was not caused by human hands. A deadly weapon was used to accomplish his murder. So that overarching question about the crime is probably an easy one to answer. Probably the easiest one after that is, was Mr. Gehrman over 60 years old at the time the crime occurred? And he was 69 years old at the time it occurred. So let's talk about first-degree murder. As Judge Levitt explained to you, there are three theories, three pathways that you can reach a verdict of first-degree murder. The first one is a willful, deliberate, and premeditated murder. The second one is murder perpetrated by means of lying in wait. And the third one is murder perpetrated during the course of elder abuse. Now, the first form of first-degree murder is probably the one you're the most familiar with, and that is a murder that is willful, deliberate, and premeditated. And you'd have to find all of those elements in order to find Mr. Tellis guilty under that theory of first-degree murder. So let's talk about what each of these mean. Willfulness is very simple. It's simply an intent to kill. Do your actions demonstrate an intent to kill? So this part of the video takes about 2 minutes. The entire time of that 2 minutes, Mr. Tellis is attacking Mr. Gehrman with a weapon. So that demonstrates an intent to kill. He's stabbing him repeatedly. Mr. Gehrman is clearly trying to fight back, but Mr. Tellis doesn't stop. It keeps going and going and going. And it's kind of a long time to be inflicting injuries on another individual. He finally walks out on the side. But the duration of that time, the entire time, Mr. Gehrman is being attacked. So let's talk about deliberation, which is the second element. Deliberation is determining upon a course of action to kill as a result of thought, including weighing the reasons for and against the action. Well, what do we know about Mr. Tellis's actions prior to the murder? Well, we know back in August, when he got notification that another story was likely coming, he kind of goes into research mode on Mr. Gehrman, where he's located, what kind of car he might be driving, searches on his computer. All of that demonstrates deliberation. Even if you didn't have all of these actions back in August, the length of time of the actual attack itself is sort of a shorter version demonstrating a course of action to kill, right? In the course of 2 minutes, you are stabbing someone multiple times. You could change your mind, but he doesn't do that. He keeps going and going and going, not even withstanding all this pre-planning. Now, premeditation is the last element of that first theory of first-degree murder, and that is simply a decision to kill before you do it. Before you came in and sat as jurors, you may have thought that premeditation is always a case of pre-planning in months in advance and that sort of thing. And that is definitely a case of first-degree murder and kind of exactly what we have in this case. But you're told by the instruction that premeditation need not be for a day, an hour, or even a minute. It can be as instantaneous as successive thoughts of the mind. So what that instruction tells you is, in the law of Nevada, for premeditation, if I make a decision to kill you and I do it a month from now, that's premeditation. If I make a decision to kill and I do it a week from now, that's premeditation. If I do it an hour later, it's premeditation. If I do it a minute later, it's premeditation. If I do it a second later, it's still premeditation. And you have a video of the attack on Mr. Gehrman, and clearly there's a decision made to kill him. But beyond that, you also know that Mr. Tellis took the step of leaving his phone at home prior to the murder. That's indication of premeditation and planning. You know that he bothered to disguise himself by wearing the hat and the orange outfit. That shows premeditation, a decision to kill. And you also know, most of all, that he brought a weapon over to Mr. Gehrman's house, and that shows premeditation as well. So that theory of first-degree murder has been established in this case. Let's talk about the second theory of first-degree murder, which is murder perpetrated by means of lying in wait. And the instructions explain what that is. Another theory of first-degree murder is murder perpetrated by means of lying in wait. And what that is kind of taking on a place of concealment in order to inflict injury or death upon another person. It's sort of the second paragraph. It says, watching, waiting, and concealment from the person killed with the intention of inflicting serious bodily harm upon, or serious bodily injury upon such person, or of killing such a person. And in this case, you actually see the actions of Mr. Tellis literally lying in wait. He goes into Mr. Gehrman's yard and recedes to the back in order to be in a place of concealment in order to attack him later on. And that is literally lying in wait. So that theory of first-degree murder is established as well. The third theory of first-degree murder is murder occurring during the perpetration of abuse of an older person. And this is kind of like child abuse, where if you abuse a child and a child happens to die in the course of abuse, it's automatically first-degree murder. The same is true for individuals who are over 60. If you abuse an older person and they die during the course of that abuse, that is an automatic case of first-degree murder. And it's sort of a policy judgment to protect vulnerable members of our society. The instructions tell you another theory of first-degree murder is a kind of murder which carries with it conclusive evidence of malice aforethought. One of these classes of murder is murder committed in the perpetration or attempted perpetration of abuse of an older person. Therefore, a killing which is committed in the perpetration or attempted perpetration of an older person is deemed to be murder of the first degree, whether the killing was intentional, unintentional, or accidental. We have that in this case. Mr. Gehrman was over 60 years old. So by abusing him and causing his death, it is automatically another theory of first-degree murder. So this is a picture of the verdict form that you'll have back in your deliberation room, and you can kind of see on the top in all caps it says murder with use of a deadly weapon, victim 60 years of age or older. That was those very first two questions I discussed with you at the beginning of the closing that you would answer as jurors. And then as a jury, you should ask about the individual theories of first-degree murder and vote on them. So you have to vote if all 12 of you think that this was a willful, deliberate, and premeditated murder. Do all 12 of you find that it was perpetrated by means of lying in wait? Do all 12 of you agree that it was perpetrated in the course of abuse of an older person? If you find all of those, then you mark those boxes. If you are in disagreement, say only 3 of you think it was willful, deliberate, and premeditated, or some combination, you have to take a vote to decide if all of you believe that it's first-degree murder under some theory. And if it is, you mark that last box and say, we don't find unanimously under any of those 3 theories, but all of us agree, 12 of us agree that it's some form of first-degree murder. The law tells you, although your verdict must be unanimous as to charge, you do not have to agree on a theory of guilt or liability. So if all 12 of you agree one form of first-degree murder, then you mark that last box. But it's the state's position that all 3 of those theories, willful, deliberate, premeditated, lying in wait, and elder abuse, clearly apply in this case. And really, Mr. Tellis isn't disagreeing that this is a case of first-degree murder. He's just saying that it was a Compass Realty assassin who did it. Now here we see Mr. Tellis leaving his house at about 9:12 a.m. And it's the state's theory, of course, that at that point he's left his house and his cell phone is sitting back at his house on Spanish Steps. The state's theory is that Mr. Tellis leaves his residence, leaves the phone at the residence, and is proceeding to Mr. Gehrman's residence. And as we've discussed, the Yukon is seen at Rock Springs at about 10:26 a.m. Here's 2 different images of it. Meanwhile, Mr. Tellis's cell phone, which is sitting back at Spanish Steps, is getting some incoming messages. There's an incoming and unanswered message at about 9:44 a.m. about a work case. There's an incoming and unanswered message at about 10:16 about another case at his work. There's an incoming unanswered message from his wife saying, "Where are you?" at 10:36 a.m. Now you'd think, given that some of the allegations in the articles, this might be one he'd answer pretty quickly. There's an unanswered incoming call from his wife at 10:43 a.m. that doesn't get answered by him. And there's another incoming call that occurs at 11:16 a.m. Meanwhile, he is at Mr. Gehrman's house. So ask yourself this: if this was really a Compass Realty assassin who was committing the murder at Bronze Circle, how would that individual know that Mr. Tellis, with his phone at his house, wouldn't have answered a call, or wouldn't have gotten in another text string, or wouldn't have made a call himself? How could anybody but Mr. Tellis be the killer? No one would have that level of assurance, because if any of those calls had been answered from his house, it would be clear that he wasn't the one involved. Now we know from the video evidence from Bronze Circle that after the murder occurs, Mr. Tellis actually returns to Mr. Gehrman's house, and he goes to the side area of the yard where Mr. Gehrman is located. And then he returns back to the Yukon. And eventually does that U-turn and drives away. But if you're wondering why there isn't blood in the Yukon, he had to walk all the way out of that crime scene, and anything that had been deposited on his shoes would have come off in the rocks. Besides that, the crime scene itself is not drenched in blood on the ground. These are Mr. Gehrman's shoes. There is some blood on them, but they're not exactly drenched, and he's the victim. So after Mr. Tellis leaves Bronze Circle for the second time, he goes east, he goes on Wintergreen, he goes on Washington, he goes on Rampart, he goes on Apple, and he goes back to his neighborhood at 11:51, and then he leaves again to go to Planet Fitness at about 12:03. You also know that Mr. Tellis is the killer because of the DNA evidence in this case. Remember how this comes into play. They collect the samples from the scene, and the Metro DNA analyst has this result of foreign DNA being present on September the 5th. They haven't even collected a DNA sample from Mr. Tellis until the 7th. So it's not like Metro or Compass Realty has a sample of Mr. Tellis's DNA to come insert in this crime scene. It's Mr. Tellis's DNA in this scene. It's literally on the body of Mr. Gehrman. The items from the search warrant also tell you that Mr. Tellis is the person responsible for this crime. Those shoes that were found in the house, they weren't planted, they were hidden. They were cut up. Anyone who planted the shoes would have no reason to cut them up. The cutting up is to benefit Mr. Tellis so he can get rid of them. If you were just planting them, you could leave them alone. And they're clearly his shoes because 1, they're in his house. 2, his DNA is present on them. And if you don't believe that, there's pictures in his phone of those shoes on a day when he apparently went rock climbing. You have the bag that was located and ultimately the hat as well. And you heard a lot of testimony about how all of this evidence was collected from the scene. There's the detective who physically finds it, working with other detectives who are also doing the search. There's the detective that's assigned to be the scribe to write down where everything is located. There's a crime scene analyst assigned to photograph it in place. There's DNA analysts who actually analyze the physical evidence after the fact. And all of this occurred, this whole search occurred while his wife is sitting in the house and aware of what they're doing. None of this evidence was planted. There's the bag, there's the hat, that was the location of the hat in his house. Finally, you know from the searches of the Bronze Circle where he accessed the Google Maps of Mr. Gehrman's house that he is the one responsible. He's not friends with Mr. Gehrman. He doesn't have business to do with Mr. Gehrman. There is no reason for images of Bronze Circle to be in his phone prior to the murder occurring. You also know that he is the one responsible from the sort of amateur surveillance that occurred in August prior to the murder itself. There's no reason for any of this to be in his phone, but that he's attempting to gather information on Mr. Gehrman. And finally, you know he actually used his work computer to gather information on Mr. Gehrman as well. At the end of his testimony, I think yesterday, Mr. Tellis explained that, he's really a victim in this. He's been victimized by the whole process. And he told you that He was wronged by his coworkers who didn't appreciate his changes that he made in the office and didn't appreciate his management style. He was wronged by the county who didn't understand that he was being a good leader. He was wronged by Zach Schilling, and by Kristen Riffle. He was wronged by them as well. He was certainly wronged, according to him, by Compass Realty. He was wronged by Steve Wolfson. He was wronged by the patrol officers who preserved that scene at Mr. Gehrman's house. He was wronged by Metro Police, in particular, Detective Gaddis and Detective Jappy. He was wronged by some mysterious, illusory phone hacker. He was wronged by DNA analysts at Metro who found his DNA on the fingernails of Mr. Gehrman. And then, of course, he was obviously wronged by Mr. Gehrman too in the articles he wrote. Or maybe it's not that he was wronged. Maybe he's the one in the wrong.
Thank you very much. At this time, we're going to take a 10-minute recess. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors, in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media, or read, watch, or listen to any news or media accounts or commentary, do research, consult dictionaries, the internet, or reference materials, do any investigation, test a theory, recreate any aspect of the case, or in any other way investigate or learn about the case on your own, or form or express any opinion regarding the case until it's finally submitted to you. We'll be in recess for 10 minutes.
Thank you. All rise. Check the hearing. order. Court is now back in session.
Does the state stipulate to the presence of the panel?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
Mr. Fasquich, you may begin your closing argument.
Thank you. Am I on? Proof beyond a reasonable doubt. It's the highest standard in this country. It's not presumption, preponderance of the evidence. It's not clear and convincing. It's proof beyond a reasonable doubt. This concept was borrowed from the Old English common law. Our founding fathers thought that it'd be better to it's better to let 10 guilty men go free than to wrongfully convict an innocent person. Additionally, I would submit to you that it reflects the reality. The very few people have the resources, the means, the wherewithal to prove their innocence. You know, you heard testimony by narrative by the defendant, Mr. Tellis. Generally, you don't discuss a person being in custody, but he testified truthfully from the stand concerning his incarceration. He had testified that he'd been in custody for 2 years and that he wanted to tell you his story. Jury instruction number 27 discusses a witness's manner upon the stand. You and you alone are to judge every witness's credibility. In jury instruction number 3, it states that you are to apply the law to the facts. As we had stated at the beginning of this trial, you are the sole judges of the facts in this case. We had asked you at the beginning if you would keep an open mind, and we're certain that you have. This case is not about who called the most witnesses. The state did. This case is not about who had the most exhibits presented to you. The state did. We had asked you that at the close of evidence and at the end of this trial, if we were to sit at counsel table with Mr. Tellis and not ask a single question, not discuss a single document, not to submit a single document, if you had a doubt, and if it were a reasonable one, he'd be entitled to a verdict of not guilty. Let's talk for a minute what the state hasn't proven. And again, there is no burden whatsoever on that man. Jeff Garman DNA wasn't anywhere but at the scene of the crime. And this is significant because we heard a very able explanation of the state's evidence from their point of view. There was no blood or DNA evidence concerning Mr. Garman in Mr. Tellis's home, in or on his vehicles, in or on his clothing. None of that would implicate Mr. Tellis. There had been discussion on the state's closing wherein there was blood everywhere in this, in the Bronze Circle address. Obviously, it was a stabbing. You can see through the exhibits that you will have with you in the jury room. There was blood everywhere, on the bushes, on the bird dish. Nowhere in Mr. Tellis's vehicle do we find blood. You recall the testimony, blood presumptive negative on both doors on the driver's side, the seat belt, the brake pedal, the gas pedal, the mat, nothing. There was no blood on his person, clothing, anything else. You didn't hear from any witnesses concerning any personal knowledge to contradict Mr. Tellis's version of the events for September 2nd. There was not a positive identification of the subject vehicle or Mr. Tellis at the scene. There's no evidence whatsoever of any gloves being recovered. And you've seen, and it's fairly clear from the video evidence that you've been presented, that assailant was wearing gloves. There was no recovery of a murder weapon. That vest with the reflective strips, you didn't see that. And the pants, I mean, we had pants that were recovered. You saw the blue pants. Obviously, that didn't bear any evidence to implicate Mr. Tellis. And I would submit to you that the facts and common sense would dictate that had he been the murderer, there'd be evidence of it on these articles, on that getup that that person was wearing on September 2nd. This is a point that I would urge you to consider, because I would submit to you that's crucial in determining whether the state, and again, it's the state alone that bears the burden, has proven their case against Mr. Tellis. There's no surveillance or eyewitness testimony showing that Tellis left his house that day headed to Mr. Gehrman's home. We did hear evidence, and it was uncontroverted, and that came through Detective Gaddis, that on the day of the stop, September 2nd, it's Metro policy to have body cam. The officers that stopped him in relation to the warrant that was obtained with Mr. Jappy's, Detective Jappy's participation, it was issued at 2 a.m. on the 7th. The officers that stopped Mr. Tellis, the officers that detained Mr. Tellis, didn't have the body cam on, and that was requested multiple times. Ultimately, there was an order from Her Honor on July 18th of 2023, and after that order. And you recall going through the cam, the reports, the CAD reports, there was intervention, but again, that key piece of evidence was overwritten. It was destroyed. Again, is that indication of some wide-ranging conspiracy? And I'm not going to stand before you today and necessarily argue that there was. But what that shows is that Metro makes mistakes. Metro officers, Metro detectives are human. I mean, you think of the old proverbial idea of police officers, they're brass buttons, blue uniforms. They're human beings underneath their titles, underneath their uniforms, and they're just like all of us. They make mistakes. That shows you that mistakes are made on behalf of Metro. And the Las Vegas Metropolitan Police Department is not infallible. Let's talk about Robert Tellis's blood, or the lack thereof, at the scene of the murder. You had seen some pretty good videos capturing that person leaving Jeff Gehrman's house after the stabbing. I would submit to you that it's the state's argument that Mr. Tellis cut himself through that incident. You heard his testimony. You are the sole judges of the facts concerning that. What we do have, in addition to the state's video, is we have this assailant walking away from the 7217 Bronze Circle address. That finger was cut. That finger had been damaged by a knife or otherwise severely injured. Wouldn't there be blood? Wouldn't common sense dictate that there'd be blood in the bushes surrounding Jeff Gehrman's body, in the rocks which were recovered, in the sidewalk outside the house? Nothing. And again, it's the state's burden to present you every bit of evidence in their prosecution, and you should take into consideration the evidence that they've presented to you. But by the same token, you should take into consideration determining whether or not they have proved their case beyond a reasonable doubt, and they have the sole burden for the production of evidence. Ask yourselves what evidence is missing. Let's talk about Robert Tellis's body in relation to a struggle that the state would have you believe occurred between these two gentlemen. Recall the evidence that we had brought in during their presentation of evidence, and I believe a number of these pictures came through Detective Gaddis, and there's a lot. It's defense exhibits B through V. This is just kind of a capture of these photos, and there's a lot of them to evidence that there were no injuries to his body. Neck, front, And there's more, and we could stand here and click through each and every one, but we're not going to. You can look at them. You can ask yourselves, well, if there was this struggle, where are the markings? Where's the bruising? Where are the scratches? Defense exhibits B through V will demonstrate that there were no such injuries. Let's talk about the cell phone usage on 9/2/2022. You know, the state would have you believe that Mr. Tellis's lack of responses to junk messages mean that he was occupied with murder. And through analyst Aguero, you heard, and you had the opportunity to see through the course of this gentleman's testimony, it was uncontroverted. We went through the messages during the key hours, the key times of September 2nd. The vast majority of those messages were automated. They were spam. How many of us respond to spam? It wasn't like he had every person reaching out to him, family, friends, repeatedly. Where are you? What are you doing? It's not. The vast majority of those messages were of no significance. They were junk. Additionally, the state did not establish a pattern of phone use behavior, which would indicate that Mr. Tellis's communication activity on that day was anything different than his normal behavior. They had the devices, they had the access. You heard no testimony that his accessing his phone, his using his phone on September 2nd was anything different than the day before, the day following, the weeks before, or the weeks following Mr. Gehrman's murder. And let's talk about the deleted messages. You recall that was quite a big point that was underscored and argued through the course of testimony, and it was actually through Mr. Aguero, our expert, the issue concerning this deleted message. And you recall then we had the subsequent witnesses in the state's rebuttal that came forward with and it was through Mr. Tellis's testimony. Do you remember the watch, the Apple Watch? Then there was questions asked, what about the other device that presumably these messages were being received on? We didn't get the benefit. And again, it's their burden to compare the Apple Watch with a Pixel phone. We didn't have that. But what we did hear from that detective is that he couldn't say one way or the other. Do you remember that question, where are you? Obviously, if someone's home, they can speak with one another. But we didn't hear and we couldn't hear any evidence. And for you to just make a judgment based upon their own expert, their own witness who has special training and knowledge, say, I couldn't say one way or the other whether that message was deleted on the Pixel device, the device that they have alleged was Mr. Tellis's phone. That's significant. Let's talk about what the state does have. They've got a cut up straw hat and shoes. There's really no reasonable explanation, rational explanation one way or the other. Obviously, if this person's the murderer, why not get rid of the shoes? You'd have to presume that he had knowledge of the shoes and their whereabouts. Let's talk about that hat. Why wasn't that hat discarded? Again, we'd have to presume knowledge on the part of Mr. Tellis where that hat was. And again, neither the shoes nor the hat tied him to Jeff Gehrman's residence. We had a shoulder bag with balls in it. Do you recall that exhibit? We had a basketball and a football that looked like some sawdust, and you'll have all of these exhibits. What's going on with that? I guess you're to use your common sense, which is one of the latter instructions, and assume that this bag is somehow implicated in the murder of Jeff Gehrman. And then it winds up in a storage area in the family home with a basketball and a football and what I would submit to you looks like sawdust in the middle of it. The image artifacts from the cache of Robert Tellis's phone, as well as the vehicle and the address inquiries on Mr. Tellis's work computer, it was fairly clear through the course of the testimony that that work computer had access to the Google account that would presumably be accessed by his Pixel phone. If one has password to that, one can have access to the devices. Matt Havaness said that he could not say the date of the cached images on the files of Mr. Tellis's Google Pixel phone. We were shown a calendar. We were to draw inferences. We don't know specifically who accessed, who searched for those images, and we don't know when they were created. And I would submit to you that that's significant, and the state should explain that to you. On Defense Exhibit 03, Robert Tellis's user accounts on Dell Omnipex located the public administrator's office. Again, this is the report. You have it. This is Mr. Aguero's summation of his analysis. Again, it shows that this Google account where these damaging photos and images are shown, it's the same. It's the same account. It can be uploaded, accessed by both the cell phone and the work computer. Obviously, we know what was going on from the testimony of multiple witnesses, what was going on at the public administrator's office and the turmoil. I would submit that's something that you should consider and determine what the facts are and what the state has proven beyond a reasonable doubt. There is a positive DNA hit for Mr. Tellis related to Jeff German's fingernails. And you recall at the beginning of the state's presentation last week, you heard from the crime scene analysts, and I would submit to you that it was fairly clear that there was a little less than an airtight investigation because, after all, police officers, detectives, crime scene analysts make mistakes. Reference to the lab techs, Ms. Brown and Ms. Koljenovich, they were trainees at the time that they did this DNA collection and the processing for presumptive negative or presumptive positive blood evidence. This is significant. It was Claire Manning. She had testified, she was young, blonde. She had testified that she couldn't recall who bagged the hands. That was at the scene of the murder. You never heard testimony as to who initially bagged the hands of Jeff German's body. One would think, and common sense would dictate, that they'd be able to tell you that. They couldn't, not from a single witness. She testified that she took custody both of the fingernails and the evidence concerning Mr. Tellis, but again, she couldn't tell you who bagged the hands. Again, this Google search on the recipe, you heard that the last day of trial, like that was somehow significant. Do you recall in the recross of the detective, there was at least 2 computers at the Tellis home that were not reviewed. They weren't checked for those recipes. So again, I'd submit to you, we have a wash. Detective Mogg, Christopher Mogg, he's now retired. He's an analyst, he lives in Texas. You recall at the beginning of this trial, he gave what appeared to be fairly detailed testimony concerning the whereabouts of the subject, Denali. Do you recall on cross, it was addressed that at 9:10, that vehicle was entering in from the Piggott Elementary. And again, you saw the map, it's in evidence. You can see that this right here is not the entrance to Mr. Tellis's neighborhood. It's streets away. It's not close. He gave you testimony that apparently he drove through the neighborhood where Mr. Tellis lived, off the Spanish Steps address. He said to look for things of evidentiary value. We heard nothing. We heard nothing concerning other vehicles in the neighborhood. Do you recall the testimony that there was at least 67 red Denalis? We heard testimony that that number at one point perhaps was greater. Perhaps it was at 67, which nobody contradicted, but we never heard what was ultimately narrowed down to. We had Detective Mogg, and I'll refer to him as detective because in essence he still is. He testified and just said he was sure that it was that man's Denali, period. Do you recall the testimony that was shown concerning, and I would submit to you because you are the sole judges of the facts, that there was something peculiar about this Denali, something in the right-hand window area, that plastic stripping. You have the photos. Please look at them. We are given testimony based upon his analysis. We have at the same part near Piggott Elementary. We have this vehicle leaving at 9:12:32. But what's significant about the 9:10, where we see it entering the neighborhood or the area, again, it's not Mr. Tellis' specific neighborhood. We're not told where it was before that, who was driving it. What's important, and I want to back up, is at 9:10, we have this vehicle entering the area. And you have to ask yourself, what's occurring between 9:10 and 9:12? If we're to take the state, based upon the evidence that they have presented, what went on during that 2 minutes and a few seconds? We don't know. Did it even make it to the Tellis' house or some other neighbor, other house in the area? But as to the 9:10, it's important because it's the state's theory, and we heard it argued that Mr. Tellis left his phone. Well, we have, and this is Defense Exhibit A3, we have that phone receiving messages. Look at the times all throughout the morning. We have that phone receiving messages 7:44, 7:45, 8:47. You can see, and this will be given to you. It's close to the cell tower next to Mr. Tellis' home. So then you have to ask, well, where was this vehicle? And I'd ask him specifically, did you follow this vehicle? Did you see this vehicle prior to the 9:10 time taken from Piggott? He didn't. But we can see, based upon the evidence that was provided to you by the defense expert, that phone is in the area all that time. It's in the Spanish Steps area. So obviously the argument, and I would submit to you, common sense would dictate, well, if that is going to Mr. Tellis' home and it's not arriving in that area until 9:10, why do we have all of these other pings at all of these other times close to the home, if not at the home? He laid out very specific detail, and he had talked about this approximately 5.3 mile trek that he wants you to believe was Mr. Tellis' vehicle, and that vehicle was occupied by Mr. Tellis. His video analysis takes 2 hours. It covers 2 hours and 39 minutes. State couldn't show you what happened during that 2 hour and 39-minute period. 5.3 mile trip to and from. They basically show you closed circuit TV coverage, which it wasn't. There was a lot of dark spots of the vehicle driving there. But then the vehicle driving back, and I won't say it was driving to and from Tellis' home because we have no evidence of that. We're to believe the state that there's no ring cameras in a fairly affluent neighborhood. I'd submit to you, does that make any sense? What we're going to ask you to look at, and please do, you've done a lot through the course of this trial. It's your duty to be here, and you have fulfilled that duty. You've taken notes. To the very last witness, it's been apparent that you've been paying attention, that you've maintained an open mind. Oftentimes we suffer, especially law enforcement, from what's called confirmation bias. You reach a judgment, sometimes early on in the case, and you work backwards to confirm what the judgment that you've arrived at the beginning should be at the end. And I would submit to you that that's what happened. This was the 1405 wintergreen. As you recall, there was an issue concerning the timing. This was channel 3, all right? This is State's Exhibit 372. You have that. You'll be given a laptop. Look at this. This was an image that was not part of his presentation to you at his testimony and during his testimony. This laptop has the ability to pause. It has the ability to zoom. Watch this. We're going to slow this down now. You have this evidence. It wasn't part of his presentation, but it's been provided to you. Look at the profile. What's that look like on the top of the head? I'd submit to you that looks like hair. We've seen Mr. Tellis. He gave testimony from the witness stand. Does that profile match the profile in that vehicle? I mean, it's no secret. The man's bald. Look at the face. Look at the eyes. I'd submit to you that those look like glasses. And again, this is part of the evidence collected by the state. It's been presented to you. It wasn't addressed during their case in chief, and it wasn't explained by Detective Cliff Mogg. I'd submit to you, look at that image. There's hair. There's glasses. Now, the state in rebuttal, and we'll address the significance of that, they have the opportunity to come and address what I've presented to you, but that's undeniable. What I'm going to show you next is the image on channel 2. That's the same video coverage, but now it has the vehicle coming from a different direction. It's parked. Do you remember the testimony from Mr. Martinez? I think it was John Martinez, of no significance. It was fairly unmemorable on that date. He said he saw the person. Nothing caught his attention because nothing was memorable. There's no talk of a disguise. Glasses, nothing. It's bland. Nothing was memorable. Take a look. Oh, hang on. That's Mr. Martinez that I had discussed. Look at this image. Look at the profile. It's hair. We have 2 captures from 2 different angles. The profile does not match the profile of Mr. Tellis. And they're consistent. It's not open to dispute. You know, you've heard testimony, and you heard it primarily through Mr. Tellis. You heard it from Nicole Lofton. Mr. Tellis was fairly concerned about the goings-on with Compass Realty in relation to errors, in relation to the trampling upon the legacy of errors by the mismanagement of the properties that were left through intestacy. I would submit to you that Detective Jappy inserted himself into the murder investigation. And again, I want to draw, a couple of arguments from this Compass Realty testimony. I mean, we know that Mr. Tellis was very concerned about Compass Realty. He was the whistleblower. He was concerned about the actions of Compass Realty. During the 2 years that he's in custody, I mean, what would a man do? He's fixated on that. He's ruminating on that. I would submit to you that common sense would dictate, and your experience would dictate, well, he's going to focus on the involvement of individuals who he was focused on prior to his being arrested. I mean, really, what are his alternatives? And again, this goes back to the burden on the state and not the defense. What can he really do when he's locked up? He's going to focus on Compass Realty. It's easy to dismiss him as being crazy. Oh, that's Looney Tunes. But hey, he's been in custody for 2 years. He was worried about Compass Realty prior to being incarcerated. He was worried about the goings on with the old guard, about his work at the public administrator's office for financial reasons. He testified concerning, and you've heard testimony supporting that. Why wouldn't he continue worrying about that? Why wouldn't he keep thinking, well, I'm being framed, I'm being charged with a murder that I don't think I committed, I didn't commit. He's going to focus on what he was focusing on before he was arrested. We heard testimony from Detective Gaddis. Do you recall the exhibits, the information that was presented about the release on September 5th? The video release of that individual walking. They started getting tips. Do you recall the email that was in her 70-page officer's report where she had communicated with Detective Jappy predating that? The first communication that we have on record and that's referenced is September 4th. Detective Jappy, when asked, did you incriminate him? Did you give him, did you give her evidence implicating him in this crime? And he said, I gave her information. But then we heard from Detective Gaddis that she had a communication with him again on September 5th. And again, she was given motive. In Detective Jappy's mind, she was given motive to focus on that man and his alleged motive to kill Mr. Gehrman. So he wouldn't agree from the stand that he implicated Mr. Tellis, but to call a detective or to email a detective on September 4th, and then again on September 5th and say, look at this guy. He's got a motive to kill. How could it be anything but an implication? You heard crime scene investigator Baxter. Her testimony concerned the goings on at the public administrator's office during the execution of a warrant on September 8th, 2022. Her testimony, and it was adopted by Detective Gaddis, she stated Mr. Jappy, she said Detective Jappy, was taking his own photos and collecting his own evidence during the search warrant at the public administrator's office on September 8th. And it wasn't a mistake, because it was asked to her on cross, and it was confirmed what she had said before you, the sole judge of the fact, by Detective Gaddis, the primary detective concerning this homicide investigation. We had heard testimony that Mr. Tellis, as a result of the warrant obtained by Detective Jappy on August 17th, 2022, that man was under surveillance. It appears until Detective Jappy inserted himself into this investigation, we had dual investigations, a short one and a much longer one concerning Robert Tellis. We know from Detective Jappy's testimony that he was exonerated. There wasn't this kickback scheme. He had been implicated by an agent who was a real estate agent who was a detective at the time. That provided to Detective Jappy in part the probable cause to get that warrant. So we have a member of Metro giving another member of Metro evidence, testimony, opinions about a kickback scheme implicating Robert Tellis. We also had heard through testimony that Compass had a direct line into the public administration office. And again, I discussed Mr. Tellis as being incarcerated because I would submit to you it's understandable why he believes there's this wide-reaching conspiracy. What other options does he have in his circumstances, under these circumstances? We do know that the district attorney's office refused to pursue action against Compass Realty. And again, I'd submit to you that that's significant. You know, the purpose of closing argument is for counsel to stand before you and highlight the evidence that's been presented to you. I'm not going to stand here and go through every witness, discuss every piece of evidence and all the testimony, because you have been here. You have been attentive and you are fulfilling your duties. You're being good jurors. But again, my job is to argue the law and, in essence, the facts to you and what we feel is significant. As I said at the beginning of my remarks, it's the state's burden and the state's burden alone to prove this case beyond a reasonable doubt. This is our last opportunity to discuss matters and discuss the evidence and the inferences to be drawn from the evidence. Mr. Hamner now is going to take the floor and he's going to argue concerning matters that I perhaps didn't bring up. Address those on your own. Look at the evidence. You've got over 36 exhibits that were marked and admitted through the defense in this case. Watch the videos. Look at the drive concerning those images of that gentleman with hair, which Mr. Tellis does not have. But since the state carries the burden and the state alone, they get the opportunity to get 2 bites of the proverbial apple. Mr. Hamner now can stand and argue why you should convict Mr. Tellis. And I'm going to ask you with your open minds and your attentiveness to address those concerns. And at the close of this process, you find Mr. Tellis not guilty.
Thank you very much. Mr. Hamner, you may begin your rebuttal.
Yeah, if I can just get a minute just to set up.
Sure.
Okay, thanks so much. Can you take it? Absolutely. I will do that too. If we can move, is it possible to move the podium out of the way? I'm not going to move the podium. Thank you. It needs to be plugged into my laptop. Does that flow on? Everybody hear me okay? All right. This is quite the setup. Okay. May I proceed? All right. Well, it's been 2 weeks. You guys have heard a lot of evidence. We thank you for your patience, and I will try to be as brief as I can. But as you've seen, with witness after witness after witness, the evidence is absolutely clear. The defendant murdered Jeff German. He murdered him because Jeff's writing destroyed his career. It destroyed his reputation. It threatened probably his marriage, exposed things that even he admitted he did not want the public to know. And he did it because Jeff wasn't done writing. He was informed on August 8th that a records request was being made by Mr. German long after he had lost the race, well into his lame duck remaining administration as a PA. And he learns that Jeff wants to write more. And when he learns about the subject of it, it's not about him and Alicia. It's not about him and Rita. It's not about anybody except him and Roberta. And what you see unfolds over the course of a month. We learn from his phone expert that he shut off all location data, even though that phone, as we learned from his expert, 13 years of location data magically disappears for the month of August. Why? Because of the August 8th email. He's over it. He's building a reconnaissance case. He starts to go on to Google Maps. He starts doing surveillance at Popeyes. He's using the power of his office and their computer software to find private details about Jeff, so it can culminate in murdering him. And that's what he does. But as I've told many, many juries, especially in the last few years, it is really, really hard to plan the perfect murder in the digital age because you leave too many breadcrumbs behind. And he's no dummy. He's actually quite smart. He is thoughtful. But you will see during this rebuttal, there are mistakes that he makes. And there are things that he simply cannot account for, that when a police starts to look into an investigation and deploys the tools that the police have at their disposal, it uncovers the inconsistencies. It uncovers his mistakes. But I got to start with what he got up and told us about, the alleged conspiracy. When Mr. Tellis got up here over the course of, I think it was 3 days, and testified, it was remarkable what he had to say, and not in a good way. His testimony was incredible and not in a good way. he explained, or at least attempted to, explain this conspiracy. What we learned over the course of the 3 days, and actually the course of this trial over 3 weeks, is the conspiracy grew, and it grew, and it grew. Who's exactly in it? It starts with Compass, nebulously Compass Realty. We learned that Adam Fenn can't be ruled out, right? Because he makes donations to Rita Reid. Cindy Sauerland gets mentioned at one point. In some of those briefings, you'll see her name is mentioned. She's a source of consternation for the defendant. It expands to the old guard, as they coin that phrase. Rita Reid, Alicia Goodwin are all part of this, right? The conspiracy, and let's remember, it's a conspiracy to murder Jeff German. We then learn it expands to Derek Jappy. He's in on it as well. When he testified, he's not really able to link up why Derek Jappy would want to help Rita Reid or Alicia Goodwin or Compass Realty or Adam Fenn or Cindy Sauerland. That testimony is lacking. A lot of times when I pressed him, and I pressed him, and I'm going to explain to you one of the reasons why I cross-examined him so hard. When you stand on the stand under oath and you make allegations about businesses in our community, government service workers, and the police department, we deserve answers. I genuinely wanted to know, how is all this connecting? Explain it to me. And respectfully, Mr. Tellis absolutely failed in doing so. It didn't make sense. And that is one of your instructions, which is to use your common sense. It's got to make sense. And it actually has to link up with evidence. But a lot of times, the most common answer I would get back from Mr. Tellis was simply, well, no, I never saw Jappy take a bribe, but I think that. It was a lot of times it's like, that's just my gut feeling. That's my opinion. That's not evidence. That is not evidence. But yet, it was Mr. Tellis's answer for almost everything when it came to this conspiracy. But let's continue. It stretches out to include Cliff Mogg, Justine Gaddis, the entire DNA lab. He said there were also patrol officers in it. I asked him which patrol. I don't know which ones. And then it literally culminates with Steve Wolfson, like the DA. It culminated with him. He can't quite link it up, but he threw that name out there. And here's the thing that struck me when I took over this case. I would submit to most people, probably before ever hearing about this case, had no idea what a public administrator was. He is not a U.S. senator. He is not a governor. He is not a congressperson. He is a duly elected official who manages an office of approximately 8 people. And their job is to assist people who pass away, who don't leave a will and leave property behind. The public administrator's office is not at the forefront of everyone's mind in this community. No one learns about this until who brings the office to light? Jeff German. And what's amazing is if you believe that story about this conspiracy, all of these people and all of these entities were willing to sacrifice their reputation, their business, their police department, even the public administrator's office. They're all willing to put it on the line to kill a reporter, to get that guy, even though he's leaving in 3 months. Does that make a shred of sense? Absolutely not. But what it does give you a window into is what's in his mind. That is how important Mr. Tellis views himself. That every single one of these people, every single one of these entities were literally willing to kill another human being who is not him, just to frame him. Does that make sense? And more importantly, where is the evidence to support that? Where is the evidence that you received in this trial that supports that? And the answer is you didn't. There isn't any evidence of that. Why would Compass conspire to frame him? Why? I asked him. I wanted to know. He couldn't give a good answer. His best answer was, well, I was going to do a lot of work in the next 3 weeks or next 3 months. Has anyone ever heard of any sort of legal filings, lawsuits getting settled up in a brief, tidy 3 months? That's not a thing. That didn't happen. That doesn't happen. There was no need to frame him because they already succeeded getting him voted out of office. And all they had to do was donate a whopping, I guess, 15 grand at best to get him out of office. They didn't need to kill him. He was on his way out the door. He is a lame duck. And lame ducks don't matter. What incentive does Metro have in this conspiracy with a real estate company to frame a lame duck? That's an even bigger one. Why would they do that? What did we hear that would show us that Compass is like, hey, guess what? Hey, Metro Homicide, we need you to join us to go frame this outgoing politician. I mean, we killed the reporter. That's not important. But I want you to join us in this, and let's go frame this guy. And all of Metro's like, sign me up. Sounds great. Does that make any sense? Absolutely not. It makes no sense. And it's not supported by the evidence. And again, if Compass is literally willing to kill, why not just kill him? Just kill him. Why does Jeff have to suffer? It makes no sense. And it gets even worse. Well, before we get to that, here's the thing. When we go back, when you think about the Compass question, right? Isn't Compass in cahoots with Rita Reid and Alicia Goodwin, right? They're funding Alicia Goodwin, right? Or no, Rita Reid. They're funding her campaign against them. And who do they get to help write the story? Jeff German. Like, why would they kill the guy who wrote the stories that got this guy out of office? Why would Compass do that? That doesn't make sense. And then, yeah, if it's really a frame job, the murder weapon should have been in the house. The orange shirt should have been in the house. The DNA should have been all over the place. Like they're claiming, well, why weren't these things located? The state would submit to you, he got rid of them. He got rid of the murder weapon and the orange shirt. He cleaned the outside of his Yukon. He even admitted it. And here's the thing. We only know that he wiped down his Yukon because on that one particular day, he was being watched. He wasn't watched every single day after the murder by Metro. Did you hear that testimony? There were other days he could have wiped the interior of his car if he wished. And I've always thought about the shoes. Like the shoes to me was kind of an interesting one. My co-counsel's right. Like the only one who benefits of like chopping up the shoes is Mr. Tellis. It's this awkward amateurish way of getting kind of rid of the evidence. But I thought to myself, maybe Mr. Tellis didn't even think to like bring an extra pair of shoes. Because like what happens if he walks in and he's totally barefoot? His wife would be like, why do you have no shoes on? He probably had to bring his shoes back in. He doesn't need the orange shirt. He doesn't need the murder weapon. It is his kid's bag, right? I mean, he said those were that's my kid's sports bag. So like, you probably need to bring that back. Not sure what he was doing with the hat, I'll admit. But clearly he's chopping it up to try to get rid of it, just like his shoes. And why kill Jeff? Like this is the question that is so destructive to this defense. It's his writing that shines a light on his behavior. He is sought out by the co-conspirators to do this. And he admits, and he admitted on the stand, one of the rare times he admits it, he admitted, yeah, his writing was the difference in the election. That's why I lost. I got that out of him. He was at least willing to concede that. But for Jeff German, he's still a public administrator. His writing is why the defendant is out of the job. And therefore, under this theory, he's got to be the one who's killed. That's his reward. He's collateral damage? Like, really? Rita and Alicia are like, sorry, Jeff, you got to go. It's been really nice. Thanks for the help, but you're out now. We got to clean up loose. I mean, is that really what's being suggested here? And the answer is that is what he's suggesting. But it defies common sense, and it's not supported by the evidence. And here's the other thing. Jeff's putting together a fifth article. And now what we can tell from the records, it's just about Roberta and him. It's the salacious stuff. So who in this realm, if you think about everyone in the conspiracy, and you think about Mr. Tellis, who is the one that wouldn't want another article written about him engaging in an affair? You think Derek Jappy cares? Cliff Mogg? Adam Fenn? No, it's him. He's the only one that would have a stake in making sure that article never got written. No one in the conspiracy would want to prevent that coming out, especially not the Rita Reeds and the Alicia Goodwins. If they want that exposed, I mean, they went to have that exposed. They wouldn't want that being not put out. And I'm sure Compass Realty wouldn't either. I'm sure they would have wanted him discredited. Like, another article would in theory be great. They wouldn't have killed him. And then we have his walk. Like, he's got a little hitch in his getup where he kind of leans to this one side. You can kind of see it. There's something that is about his little walk. And look, you don't have to take my word for it. You can evaluate whether you think what Zach and Christy had to say about it. They've hung out with him. They've walked with him. They thought, and think about how they saw it. They were like, man, they kind of knew the background between Gehrman and Tellis, and they were like, wouldn't that be funny if that was him? He's got those same goofy gray shoes. Like, that was the thing. Like, they noticed the shoes, which I think is really interesting, you know? But they don't act on it at first. But it's only when they see the Yukon that they kind of flip out and they're like, well, we probably should call on this. The only other person who came and said that wasn't him is Nicole. And listen, you'll have all of Nicole's text. The state would submit to you that, look, there is no doubt she has a kinship to Mr. Tellis. You can see it in the text messages. You can see it. You can go read through them. The state would submit she has a bias. And, like, she cares about him. And I think he was probably good to her in the office, which is understandable. But look, you can judge it on your own. You can judge the testimony of those other people. You can make that call for yourself. But I would submit to you, when you look at this, think about all the other evidence in the case. Think about all the other evidence, the motive, the physical things found in his house, his DNA underneath the nails. When looking at this and being like, is that him? And the state would submit to you, when you put all that together and you watch this video, absolutely, it's him. Professional killer versus amateur killer. Mr. Tellis would like you to believe that this was an assassin with combat training. The state would submit to you, you don't need combat training to stab people. You don't have to go to knife school. You don't have to do that. If you're angry enough, you can stab people pretty good. If you got enough hate in your heart, you can really go at people. And I would submit to you, the state would submit to you, that Mr. Tellis had enough of being exposed, written about, publicized, embarrassed, and he wasn't going to have it done again. Because at this point, the state would submit, Gehrman had taken everything from him. Everything that he worked for. He worked his way up through law school. He had got himself elected, and this guy took it all from him. And so he wanted to take something from Jeff, and that was his life. Professional assassins don't use their personal vehicles. They don't use their personal phones or work computers to conduct reconnaissance. They don't wear attention-grabbing outfits. They don't flee the scene and then double back to pull right up to a murder scene to look for possibly dropped evidence. And they don't leave items of clothing or apparel they use in the murder inside their own house. Professionals don't do that. The state would submit to you that what this was an amateur attempt by Mr. Tellis to pull off this killing. But here's the thing. It is thoughtful. It is deliberate. He really did a thoughtful job about it. I give him credit. But in the world of the digital age, we leave behind too many breadcrumbs. And when you're not a professional and you are an amateur, you tend to make mistakes. And that's what he did. For example, really smart idea. He knew about IDI Core. Hey, I've got a really easy way to look up personal identifying information on people. I'll use my work computer. But what does he not realize? That we can, as the police, download the computer and literally see your keystrokes. How could he have known that? He wouldn't. It's an oversight. It's a mistake. It's a slip. And it's evidence that we collect against him. What else? He does the Google Maps surveillance. Really clever. What an easy way. You don't even have to go to the neighborhood. Just pull it up on your Google Maps. He does the Popeyes surveillance. He takes the photos off his work computer, right? But he forgets to delete his cache files. And let's just make this clear once and for all. Matt Hovanetz told us what? He said that these are not created photos. They would say created in a date, in a time, and you'd have it. Those don't exist on the phone. I wonder why that is. Why do you think there aren't all those images? Forget the Google Maps surveillance, right? That's just, those are probably images that the program pulls up. Sometimes it's referred to as tiling. But like the Popeyes photos, which are coming from the phone, and the one from the work computer, why don't we have any created photos? The state would submit to you that Mr. Tellez, being the smart guy that he is, the techie, as he described himself, deleted them out of his photo album. But the problem is, he didn't delete his cache. And we learned from Matt Hovanetz that the caching of photos is what happens. The example that we heard was, say you want to send an email, and the computer will shrink down the actual image to get down data size lower so it can go out. He didn't delete the cache. He deleted the actual photo, but not the cache. And so those dates tell us that essentially in the month of October, he is doing all of these things. He tried to get rid of it. He couldn't get rid of all of it because he's an amateur. He conducts reconnaissance in August, but doesn't realize that the police are going to acquire the 8.8 email about the public records request, right? Like, did he really? Maybe he probably didn't realize that we would go to the PA's office and say, hey, we want what communications are out there, and we get the email. Now we understand the significance of why these things are all happening in August, because we get the email. He didn't account for that. Here's another thing. He shut off all his location services in August, but doesn't realize it's going to stick out like a sore thumb during a location services analysis. And here's the crazy part. His expert gave it to us. His expert said, I have 13 years of location data on this phone, but for the month of August, it's a 0. It's a bagel. Why? Why that month? Because it's right. It's when he's planning the killing. He knows he's going to those spots. He doesn't want to be tracked. He's no dummy. He's smart. But the problem is that is an electronic breadcrumb. An entire month, no location data at all for anywhere that he traveled. That was the testimony of his witness. And he didn't claim that that information was hacked or compromised. What else? He decides to wear gray Nikes, but forgets to delete the shoes off his phone. And then he fails to get rid of the shoes in time by the time the cops do the search at his house. Maybe life just kind of gets in the way, right? He's maybe doing it late at night when the kids are asleep, and his wife's, you're just, doing a little, I don't know where he's planning on sprinkling the bits of the shoe, but like clearly he wants to do that to shrink it, and maybe it's harder to find. Like he's putting it in a place that only he would find it, like underneath the recliner. And like he can't account for like the one random photo where like his murdering shoes are right there when he's out rock climbing. Like he can't plan for that. And all the hundreds or thousands of images are there. He can't plan for that. Creates the disguise of the construction worker, but doesn't account potentially for an interaction. And then again, he leaves his phone at home, which is smart, right? So we don't see the movement of the phone kind of going with the Yukon, right? But the problem is that when you go radio silence for like 5 hours and you start ignoring your wife's calls and texts, that's a problem. And then Great example. He gets up here and he tells us the whole story about the chicken fried rice. He was so happy to share that story. I was making my daughter lunch because she doesn't eat the school lunches, and I cut the tip off and I started bleeding. So I went and got the super glue and I cut it and it got blood. And so that's why the DNA, that's the one time he was fine with DNA. But like, he doesn't realize that all we have to do is start checking it. Is there a Google recipe for chicken fried rice on your phone? And there wasn't, because that's what he said he was doing. He didn't just say I was making a meal. He specified how he was doing it. He was like using a recipe, and that's the most logical place you would do it. People are not bringing their desktop computers and putting it in their kitchen when they're cooking fried rice. Like, that's not how that's going down. Like, he was, if that their story was true, and we would submit it as not, because it's not there in the phone, he probably would have sat there with his phone on the counter, hit the YouTube or the Google recipe, and then he's working. So it should be there, but it's not, because that was something used to explain why in the world would my DNA be on the scissors. Again, another example. He goes to great lengths to park down the street. And then it all goes down the drain when he leaves because he realizes, oh, I probably forgot something. So he wheels back and parks right in front of the house. That's a huge mistake. It's an amateur mistake. Here's another one, and I just noticed it while watching it. He left the garage door open. If you watch the video after he does the killing, he walks away, the garage door is totally open. And then when he drives back and he gets out, he has two opportunities to close the door. What did we learn about what prompts the neighbors to worry about Jeff? It's the garage door. The hitman, the assassin shuts that garage door, but not an amateur like Mr. Tellis. Because in the panic of the moment, he's just like, I got to get out of here as quickly as possible. It's a slip. It's a small slip, but it's reflective of who we're dealing with. And then he forgets to get rid of the hat. He forgets to get rid of the bag. He forgets to wipe his phone entirely. Next time, factory reset, full factory reset. Hopefully that'll clear it all. Probably be up in the cloud. But the point is, he doesn't do the things he needs to do. They're amateur mistakes. It happens. That's why it's hard to pull off the perfect murder in the digital age. And about that gray bag, the defendant told us on the stand he'd like to think he wouldn't have removed his children's basketball and football to use it in a murder. Remember that? And there's the bag. And there's the bag. And there it is. And the defense in his closing arguments said, we submit that there's sawdust inside the bag. Well, let's take a closer look at the sawdust. See that bag? Let's take a closer look. Remember the big sun hat? Is that sawdust? Doesn't look like little chopped up little bits. Looks more longer and rectangular and flat. Here's the hat. Here are those bits, long and rectangular. The state would submit to you, he put his chopped up hat in that bag and then transferred the bag into the Sprouts bag, put the basketball and the football back inside. That is not sawdust. I want to touch on some things that were brought up in closing argument. That Garen's DNA is the only one at the scene. Well, our response is, well, his DNA is underneath Garen's nails. So that's a huge problem. Not in his vehicle or in his clothing. He got rid of his clothing. We'd submit he cleaned his car. He also wasn't surveilled 24 hours a day. There was no positive ID from him at the scene. And that is correct. And listen, that's why we have this instruction about direct and circumstantial evidence. Because in Nevada, the law doesn't make a difference between the two. You can weigh it as you wish. Some cases have incredibly powerful examples of circumstantial evidence. Sometimes you've got a combination of both. Sometimes it's all direct. But there's tons of direct evidence, like him in the Yukon. Like that's to be tracked from literally Silk Tassel all the way to his house and then all the way back is incredible. You heard about how many officers it took to track and go business to business to business to business. That's direct evidence. You've got the circumstantial evidence of the DNA. You've got the shoes with his DNA in it that's chopped up. You've got the hat. You have the surveillance in the phone. You have the whole motive laid out from the articles. I mean, okay, you're right. We didn't have one person standing out going, I watched Mr. Tellis stab Mr. Gehrman. You're right. But we got a whole lot of other evidence. There's no surveillance of Tellis exiting his home. You've heard testimony about it repeatedly. There wasn't cameras in the area. We just have surveillance of the street that's perpendicular to his driveway. And I thought I had pulled up, maybe I didn't, I apologize. I tried to put the image of that, but I want to address that. It might be still in here. Go back and check the map, because the way it actually works is Piggott Elementary, when he's coming in and out in his red Yukon and going to the gym in his BMW at the end, the street that comes down perpendicularly to turn out along the Piggott Elementary, that street is Silk Tassel. And when you look at a map, if you follow Silk Tassel, it perpendicularly, it runs into his driveway. Like all he has to do is like drive out of his driveway and he's already on Silk Tassel. So you're right, like we don't have him getting out of his car from his driveway, but we literally have the only street he needs to take to get to Piggott Elementary. It is not streets and streets and streets. It's the street before his driveway. There's the argument, well, Metro makes mistakes. There's that deletion of a traffic center. Well, as I've just pointed out, Tellis made a ton of mistakes himself. So we will own that, you know, on one traffic stop, we didn't mark a proper event number. And you can give it whatever weight you want. Tellis cutting himself while cooking. You know, again, we've talked about the chicken fried rice thing. That's not backed up. Wouldn't there be blood from the cut? Not necessarily. What if he had gloves on and he's kind of cutting this tip? It may not be pouring everywhere. And again, look at that scene. The majority of the blood of Mr. Gehrman is actually just kind of pooling from where he's resting. It's not splattered all over the house walls. It's not that type of scene. I mean, Gehrman's shoes are such a good example of that. Like, he's the guy who gets killed. He's the one stabbed 11 times, and his shoes are relatively clean. And he's not doing a lot of walking. A lack of responses to junk messages. That's true, but there are work messages he's not responding to, and his wife is reaching out to him, and he ain't responding for hours. That's a problem. That's a problem for him. Especially, go look at, when you're not in the murder window, go look at the communications. So like when his daughter reaches out to him in the morning, he responds like that. No issue. Like at 3 o'clock or so, or 2:30, when Tonya, his ex-wife, responds with a question about the kids, he responds immediately. And what did he tell us on the stand? What did he tell us on the stand about being at Summerlin Area Command? What was his big worry? My family doesn't know where I am. I was so worried about being detained there because I couldn't reach out to my family, because that was the most important thing. And what do we know on the day of the murder in the murder window? His wife wants to know where he is, and he's not telling her. That is significant, because his pattern is, when you look outside the murder window, he promptly responds to family members about family matters. But he goes silent with his wife when he's literally in Mr. Gehrman's neighborhood. And another thing, remember his face when I showed him the Apple photo for the first time? If anybody remembers, store that one away. Because he was very comfortable on direct talking about the timeline. And he had his story all lined up. And when I showed him the photo, that the message that wasn't there, that face really changed. And you can weigh that when evaluating his credibility and his responsibility for this. And then there was the argument about DFL analyst Hovannes couldn't say one way or another if it was deleted. Well, you're right. He's like, I can't definitively say it. What he does say is, I can see from the photos the message is there. I can see in the timeline it's not there. Sometimes there are situations where people delete things deliberately and it's marked as deleted, so it'll appear in an extraction report. But sometimes people delete messages and it's not. But he can't definitively say for certain. So I would submit this to you, ladies and gentlemen. Look at all the surrounding evidence in the case. And then you can reach a conclusion about this. Because, ladies and gentlemen, circumstantial evidence is a chain of facts that lead you ultimately to a conclusion. It's like connecting the dots. And so if you're wondering about this, look at the phone evidence. Look at the motive. Look at the physical evidence in his house. Look at the timeline of when he's gone. Look at when the Yukon is where it is in relation to just nothing is going out on this phone. And then you decide, you can make a call about whether, and his manner on the stand, listen to him testify. And then you can decide whether he actually deleted that message. And I'm going to get to the significance of why maybe that message was deleted in a bit. And again, Hovanec couldn't tell you the cache date on the phone. The state would submit, and you can check your notes, that's not his testimony. He never said, I can't tell you the cache date. He said, I couldn't tell you the creation date. He said, the cache date is something different. That's what the report is showing me. That's the last time this image interacted with the phone. So that's the time that those smaller images are interacting with those phones, all those dates in August. Not bagging the hands. And that was an argument being made. Like, no one could tell us exactly. So I would say, what means what? Has there been testimony that the DNA evidence was compromised? There was no evidence of that. What is being asked of you? You're being asked to speculate. And you have an instruction on reasonable doubt. And reasonable doubt must be actual, not mere possibility or speculation. Speculation doesn't get you there. It's improper to speculate. Here it is. I knew I didn't forget it. Colin was streets away from his home. That's not correct. That's his house. This is the road. When you're watching that Yukon come in and out, and his BMW coming out, this is what you're seeing. So you're right. We didn't get any homes in this area with camera footage. But we got about 5 miles worth other than that. There was an argument, does it make any sense that there aren't any other cameras in the neighborhood? And my response would be, did you see Mog's presentation? Does this appear to be a case of Metro's not interested in collecting video? There's like 28 sources. The state would submit to you, if there was a camera that was working, that was closer to his house, they would have gotten it, and we would have wanted it. And then there was the video that they showed of this other car, right, with someone presumably with hair and glasses. The state would encourage you, by all means, go compare it to the rest of the videos. Compare it to the rest of the videos. And compare it with all the other evidence, and then you get to weigh it. Because we did hear from Mr. Martinez. What did he also say was going on in that neighborhood? There was a 7-day-a-week, 24-hour construction project where they're repairing a sewer line. I asked Mr. Martinez, what did you guys wear? We wore orange things, right? And in that video of that car, there's someone in an orange thing. Is it possible that that's one of the workers from the sewage project? He seemed to be coming down the road in that first video. He's coming from the road where Mr. Martinez said he was waving people off. Remember? Martinez said, I saw that when we saw the first video, right, of the car approaching and the white truck pulls up, he said he was going out there to tell that person, you can't come down this other way. And the video that the defense shows you shows a car coming from that other way. And if we marry the testimony of Mr. Martinez, the state would submit that's the construction area. In all likelihood, that's just another worker. But you get to weigh it. You get to weigh it with everything else. Then there's this argument about Jappy mysteriously inserting himself in the homicide event. Really? Is that the testimony? Detective Jappy told us that he had to attend the Metro briefing that night. Why? It makes sense. He's literally a detective that's working on an investigation on him. Does it make sense that Metro would want all people maybe involved or some kind of connection? Absolutely. But did you really hear a situation where he was injecting himself into Justine Gaddis's investigation? The answer is no. Detective Gaddis talked about contacting him from time to time, and when contacted, he either met the person or responded, but there really isn't any evidence of him interfering with an investigation. And then here's the other thing. There's testimony from a CSA saying he was taking his own photos and collecting his own evidence. What is the significance of this? We do know from Detective Jaffe, he is conducting 2 investigations at that time for Compass and Telus. It goes on until January of 2023. So is it possible he is collecting information tying to one of those? It's possible. But the better question is this: what evidence do we have that Jaffe's presence being there compromised any CSA's collection of the information they needed to get? Did you hear a CSA say, like, he didn't let me pick up that computer that I needed to take? He didn't let me take Roberta's computer. Did you hear anything like that? That he was some sort of obstacle from the CSAs doing their work in the PA's office? The answer is no. So what is the point of bringing this up? It is an argument or suggestion asking you to speculate, because there isn't any evidence that he interfered with their collecting of evidence at the PA's office. It's not there. And then the DA didn't pursue charges, and I would submit that was significant. That's what he said. Respectfully, the defense doesn't expound upon the significance. He just said it was significant, but doesn't expound why. Why is that significant? He never explains it. It just stops. And the state would submit to you the testimony of Derek Jaffe is really significant, because Mr. Tellis would have you believe that, like, he's being framed by Derek Jaffe and his complaints about Compass are not being taken seriously. And he got up on the stand and Derek Jaffe told you the exact opposite. He exonerated Mr. Tellis from what he was hearing from Reader Reed and people in the PA. He exonerated him. But he's supposed to be the head co-conspirator for Metro. Why would he exonerate him? And then he did go to the DA's office and said, I think we should pursue charges against Compass, and was told, listen, due to this loophole, it's not going to work. Like, you have inconsistent information about what these people are notified or not. And the court records do show that, Cindy Sauerland is identifying, when they want to file on this case or, notify next kin. Like, there's records that match up. So even it's just like, it's literally the exact opposite of what Mr. Tellis wanted to have uncovered by Jaffe. And like, he didn't, if he really was out to get him, like, he should have just stopped when the arrest was made and we could be done. But that's not what he does. So I want to get to the defendant's testimony. There's a credibility instruction. You were instructed that you need to consider witnesses, and since he testified, he's a witness, consider his manner upon the stand. Think about what his fears, motives, interests, or feelings are, and the reasonableness of his statements, and the strength and weaknesses of his recollections. And then here's the kicker. Under Nevada law, if you believe a witness has lied about any material fact in the case, you may disregard the entire testimony of that witness or any portion of their testimony, which is not proved by other evidence. The state would submit to you that arguably, Mr. Tellis' testimony, he might have been our best witness. Based on his manner on the stand, based on the things that he said, he spent 2.5 hours on that first day, and almost 80% of it is talking about things he did in the public administrator's office. It's not about the actual murder or what he's doing on that day. He just wanted to regale you with all of his achievements as a public administrator and how he fought against people standing in his way. The state would submit to you, as my co-counsel told you in opening statements, that's not what this case is about. It's not about whether he was a good manager or not. It's not about if he had an inappropriate relationship. This is about whether or not he had a motive to kill Jeff Garriman, and did he in fact do it? And he did. Think about his difference in how he spoke to you on direct on a narrative versus trying to answer my questions. How many times did I have to repeat, sir, my question is this, bring you back to my question. Sir, I didn't ask you why. I asked you a yes or no. Think about that for a second. And think about this. What are his fears and motivations in this point in time when he sits on that chair and he's talking to you? And we're going to get to something about that I think is very significant. And it's right here. He took the stand and he admitted on cross-examination that he lied. during his May 11th, 2022 interview with Jeff German. I asked him, what was it the part that you were untruthful about? And he said, it was about my relationship with Roberto. And he said, and I said, he said, I didn't think the public should have to know about that. And it was really important to conceal that information from his family. This is really significant because what it tells you is that back in May, when he was facing just an election, he was willing to lie to protect his job and to save his marriage. Now, the stakes are even higher. They're far higher. So you get to evaluate, are the things that Mr. Tellis is now saying, is it possible he could be lying about some of those details? Because this is far greater than that. Think about the difference in his body language, his ease of sharing information when I'd ask versus when he just had free reign to say whatever he wanted. They're like night and day. And the state would submit that the defendant's view of this situation is completely divorced from the evidence in the case. It's like he's talking about a thing it couldn't be farther apart. He talks about these conspiracies, but he's so short on details. Always. Oh, he took a bribe. Did you see someone take it? No, I didn't, but it's just in my gut. I think that happened. That doesn't work. That's not evidence. Something in your gut, or I just feel it. That's not evidence. And when you think about it, it does make sense. Because if Mr. Tellis had to be honest about what the evidence is in this case, it's a very difficult thing for him to explain away. It's his DNA underneath the fingernails. It's his car that's there. It's his Google Maps images in his phone. He's conducting surveillance at Popeyes. He's using his computer to look up information on this guy. He's got these text messages explaining how upset he is about everything involving Gehrman. That's a huge problem because really he's the only person who wants Gehrman dead. He's the only one. And really, this was kind of in my mind what jumps out to me. It's like a because I said so. Like when I pressed him on things, like why is this? Why is this? And it was just simply because that's how I feel. That's not evidence. And again, the defendant is also selective during his testimony about what evidence had been compromised versus properly collected. Great example was the scissors DNA. At the beginning, I'm like, the DNA in the fingernail, you couldn't get an inch out of him agreeing with that. I'm like, you at least agree with me that it's been planted, and you didn't even want to do that. But he had come up with a story about cutting his finger, so he's fine with that DNA being on the scissor. That's a nice contrast. And he picked and chose, and you can check your notes on that. But that to me is really significant because he was fine talking about certain pieces of evidence that he thought was good. Great example, the timeline on direct. He's happy to tell you his narrative on direct because he forgets about the where are you. And then on cross, when I confront him with the where are you, now things are a little bit different. But he had no issue with anything in that timeline at first. And another thing, when the defendant testified, a lot of times he didn't use phraseology like, I didn't do this, or I didn't do that, or I didn't stab him, or I didn't go to that scene. It was never that. I mean, maybe from times he would say it, you'll check your notes, but the vast majority of the time, Mr. Tellis would say it like this. I'd like to think I wouldn't do something like this. I'd like to think that I wouldn't do that. I'd like to think I wouldn't take my children's sports balls out of the bag to use for a killing. It's an interesting phraseology. The state would submit it's a bit of a tell. Because he could have just simply said, I didn't do that. I didn't touch that bag. But that's not how he words his behavior. It's this like Monday morning quarterback. I'd like to think I wouldn't because it's really bad. You can weigh that when you're evaluating how honest and truthful he was when testifying. And again, for all his talk about being conspired against by powerful enemies, it's actually the defendant that uses the power of his office's proprietary software to spy on and discover where Gehrman lives and what type of car he drove. He used the power of the office, Mr. Tellis. And here's another thing. Remember the map that they brought up, kind of trying to show the drive from the PA's office to Popeyes? When you study that, remember it's Analyst Hovanet's testimony. Those reports out of Axiom from the work computer aren't converted for UTC time. So he was trying to use it to say, like, I couldn't have done this at this certain time. It's not UTC converted. And then we get to where are you? Remember, every single message between the defendant and his wife on 9/22 are on the timeline, with the exception of where are you? So here are the messages, where are you? Now they're talking about his daughter, collecting or selling things. Wow, that's incredible. There's a doctor's appointment. Are you at the doctor's appointment? No, we're at the barbershop. Oh, okay. Then there's a text about the scheduling of the appointment. And then he also has picture read. All of that's on that Apple Watch. Oh, and also the deposited message. And then when you look, it's all the same stuff with the exception of where are you? That's the one thing that's not there. There's the cards thing. There's that's incredible. At the doctor's appointment, the barbershop. Oh, okay. The appointment last week, picture day, and then the deposited message. It's all there except for where are you? So why is this significant? Number one, the defendant cannot answer this text or pick up her call because the phone is at home while he is murdering Gehrman. Number two, the defendant couldn't leave this message on his phone. Why? Because it would reveal that even his wife is looking for him at the time of the murder. And third, given the state of their relationship at that juncture, given what you've now kind of acknowledged what he was doing privately, if your wife calls and you have your phone on you, you're going to take that call. You're going to answer that text message. You're not going to let that sit for like 5 hours. No way. No way. Some final thoughts. I want you to think about this one. This is something I never actually asked Mr. Tellis on the stand, and I really tried to ask as many of these, but this one really struck me. The Las Vegas Metro, the Metro Police Department, the Las Vegas Metropolitan Police Department was really in on a conspiracy to get the defendant, right, to truly get him. Here's a question for you. Why not let him die in the tub? You saw the video. Why not let that man bleed out? You had your opportunity, and yet they don't take it. Mr. Tellis's life is saved that day. And who ends up saving his life? Why, it's none other than the head conspirator from the Las Vegas Metropolitan Police Department. It's Detective Derek Jappy. He testified that he spent 2 hours on the phone talking him off this ledge. 2 hours. And then you got to watch the footage. They saved his life. If the conspiracy is really true, Derek Jappy doesn't do that. Metro doesn't do that. They literally let him bleed out. But that didn't happen. And the reason is, ladies and gentlemen, is because there never was a conspiracy. You made a commitment when we did voir dire to follow the law. The law in this case is abundantly clear. These three theories of liability are abundantly clear. He is guilty beyond a reasonable doubt on all three theories, and it's not close. And so we ask you to follow the law and follow the evidence. Do not speculate, but follow the evidence. As my co-counsel brought up, in the end, this is not a case about politics. It's not about alleged inappropriate relationships. It's not about who's a good boss or who's a good supervisor or favoritism at work. It's just about murder. And I want to end, if I could, I'll make sure that this is working, with something that Mr. Tellis said in his interview that really struck me. And I noticed it during the opening statement. And it's this.
And people just cannot get to do whatever they want.
And it's just that people don't get to do whatever they want. For once, the state of Nevada is in agreement with Mr. Tellis. He doesn't get to do whatever he wants. He took the life of an individual who was simply doing his job because he didn't like how it impacted him personally. Please hold him accountable for murdering Jeff German. Thank you very much.
Okay, at this time, the clerk will swear the officers of the court who will take charge of the jury panel.
You do solemnly swear that you will keep this jury together in some private and convenient place, that you will not permit any person to speak to them nor speak to them yourself, unless it be by order of the court, except to ask them whether they have agreed upon a verdict, and that you will return them into court when they have so agreed, so help you God?
Yes.
Okay, at this time, ladies and gentlemen, you're going to be excused. When you go back, you're going to have lunch. After lunch, we are two alternates, Mr. Max Gross and Zachary Crayson. You will go with one of the court officers. At that time, the clerk will bring back all of the evidence and you'll begin to deliberate upon your verdict. So when you're done eating lunch, make sure Officer Hawks knows and the clerk will bring back the evidence. Thank you very much and you're excused.
Thank you, all right,
Yeah.
Okay,
Please come in just one second.
okay, no problem.
He's putting his tie on there.
The record reflects that the hearing is taking place outside the presence of the jury panel. I received a note from the jury foreperson. It's been marked as court's exhibit number 24. First question is, can we have more paper? We have taken more paper back to him. And the next question is, how do we zoom in on the videos? I don't know how to do that. We don't, that's why we asked you to bring your IT person. And so,
Who do we have?
sure. I mean, I don't know if we can show them, if we can show the foreperson how to do it, or we'll have to bring them back in the courtroom.
Do you know, is there a way to zoom in on certain videos?
Well, Mr. Draskovich did it.
I know how to do
Yes,
You did it.
Mike knows how to do it.
I do, I can try to do
Okay, but they have a laptop back there.
And I was told it did have a Zoom capability, so that was,
Okay, will you just come up and state your name for the record?
Sure. My name is Jetta Baldami.
Okay, if we brought the laptop out, would you be able to determine?
Sure, I can take a look at it, depending on what the player is. It should have that capability.
Do you know what the player is on the,
I've never seen the player before, so I would have to inspect it.
oh, you mean the laptop, whatever's on the laptop?
Yeah, yes.
Okay, so I'll go out and I'll ask the officer of the court to ask the foreperson to bring the laptop out. You want to come in the hallway?
Sure.
The attorneys can come back here.
all right, thank you.
Oh, sorry.
the record reflect that the hearing is continuing to take place outside the presence of the jury panel. The state, and that's an employee from your office, correct?
That's correct.
Jetta Balgami. She went with the court officer back into the jury deliberation room, showed the jurors how to do it, and they did that without objection. Is that correct?
That's correct.
Mr. Jaskowitz?
Yes, Your Honor.
Okay, and so they're continuing to deliberate.
Thank you.
Thank you.
Your Honor.